everyone, and welcome to Eavesdropping, Consent and the Law, what every attorney needs to know about Penal Code Section 632. I'm Ala Policastro, CLE Advisor for the Beverly Hills Bar Association, and today I am delighted to introduce our speaker, Arash Hashemi. Arash is the founder of the law offices of Arash Hashemi. Arash handles a wide variety of criminal cases, from petty theft to complex felonies, including murder, with a particular focus on self-defense cases. He represents thousands of Californians accused of violating probation or parole, including before the California Court of Appeals. Arash is a frequent volunteer at the Massaro Free Legal Clinic in South Los Angeles and recent past president of the Criminal Courts Bar Association. And now let's get started.
Evening, everyone. How are you? As you heard, my name is Arash Hashemi. So I do have some slides up. I'm sure you've all gotten these. I'm going to jump around a little bit. I'm going to try to stick with the slides, but I'm going to jump around. So let's talk about Penal Code 632. The first thing I want to do is talk about the learning objective. So we're going to talk about the Penal Code itself. But before we go into these learning objectives, let's read the Penal Code. So in practice, criminal defense at least, as a young lawyer, I was taught whenever your client is charged with a certain penal code, first thing you should do is read the penal code, because you're going to get the elements of the crimes that are being accused. So let's read this penal code. California Penal Code 632. A person who intentionally and without consent of all parties to a confidential communication who uses an electronic amplifying or recording device to eavesdrop upon the record, the confidential communication, whether the communication was carried on among the parties in the presence of another or by means of a telegraph, telephone, or any other device except a radio, shall be punished. There's more to it, but let's talk about that. The reason I wanted to read that is, sorry, I was reading I thought there was a question. So California is a two-party consent rule. We have to understand the California's two-party consent rule. Now, if you remember in law school was a long time ago for me, but they were talking about two-party consent and one-party consent when it came to certain laws. California is a two-party consent rule, meaning that both parties in the conversation have to give consent for the conversation to be recorded. This actually, the penal code was put into place in 1967. They were worried about advancing technology back then. Advancing technology back then was the personal tape recorder. So they were worried about privacy. So they enacted this penal code. So you are found guilty of a crime if you violate these key elements. One is intentional. It has to be intentional. You intentionally record the conversation. Two, you use an electronic device to eavesdrop or record. Now, what does eavesdrop or record mean? You don't necessarily have to record the conversation. You could eavesdrop on it. So if you've seen in some of those movies where there's the PI sitting across the street and he has this amplified thing where he can hear conversations across the street really well, he might not be recording, but he's eavesdropping. So Penal Code 632 applies to him because it's eavesdropping. So it's not just recording, but it's also eavesdropping. And then it has to involve a confidential communication. That is key, confidential communication. We'll get back to that again. And it has to be without consent of all parties. So if one party consents and the other one doesn't, then you're in trouble. So let's go back to the example of the PI. The PI is eavesdropping on someone. It's two people having a conversation. He's eavesdropping on them. He's not involved. So he's not part of the consent. But let's change the example. I'm talking to you and I'm recording you. You're not knowing. So I consented to the recording because I'm the one actually doing it, but you haven't consented to it. You don't know about it. That's where I get into trouble. So the consent part doesn't apply to the eavesdropper because he doesn't need to give consent. He's not part of the two parties to clear it up. So it is a misdemeanor offense. It's punishable by a fine up to $2,500 per violation and imprisonment in county jail up to a year. All misdemeanor offenses in California, you can only go to county jail for up to a year, no more than that. And the fine maximum could be 10,000, and this is 2,500 per incident. And there's also civil liability. The civil liability is defined under Penal Code 36, I'm sorry, 637.2. We'll get to that as well. Um, so these are our learning objectives. We're gonna talk about the two-party consent rule, identified what qualifies as confidential communication, distinguish between what's lawful and not lawful, recognize the key exceptions and defenses, navigate evidentiary issues, and advise and how you should advise your clients. I do have some more stories I will talk to you about. So again, Penal Code, the 632, the overview is prohibits intentional recording of confidential communication. Now, intentional is a key word you have to pay attention to. If I'm talking to you and my cell phone is recording and I didn't know about it because it was recording from a prior conversation, or it was recording because I don't know, my assistant had accidentally touched it, or my kids were playing in the background and it was recording. Later on, I find out it was recording. It has to be intentional, okay? At the time, it wasn't intentional. So, can you go on and say later, if I used it, then it becomes intentional? Maybe. We'll get to that. It applies to phone and in-person and electronic conversations. So, phone conversations, if I'm having a phone conversation with you, and I'm recording it, that is one of these intentional recordings that's confidential. If you notice, you call some call centers and say this call may be recorded for operating purposes, they're actually telling you, okay? So you agreeing to continue with that call is you giving them consent. So later you can't come back and say, oh, you violated my rights and you were recording me. They gave you notice in the beginning and you didn't object to it, so that's consent. Technology is great. In my office, our system has AI taking notes. So if I'm talking to a client, it will say AI is taking notes. Obviously, I tell my clients, hey, I'm going to take notes so I can have this conversation later. It's confidential. It's still going to be confidential. It's going to be in your file, but we give them notice. If some of my clients say, no, I don't want you to take notes, and sometimes I don't want to take notes because I'm talking to them about their case, so we turn that feature off. But if that feature is on and me not telling them, and the feature itself says AI is taking notes and the client doesn't say anything, they've consented. Obviously, the attorney-client privilege still sticks there. I'm just giving that an example. And then it could be the violation could be criminal or civil, meaning that if you don't get charged for it, you could also get sued for it. The other party could sue you for it. We'll get to that part. And then California Penal Code 632A is where the elements we were talking about is. Let me see. Okay. I just wanted to make sure that the questions or the chat wasn't for me. Okay, so let's talk about the next slide. I don't know if it's working or not. Okay, this slide doesn't seem, oh, there we go. Okay, so defined in 632C, there has to be a reasonable expectation of privacy. And then the case is Flanagan versus Flanagan. But before I get to that case, let's talk about, we talked about the legislative intent. Let's talk about the reasonable expectation of privacy. But before that, what is a confidential communication? So the expectation of privacy is what creates the confidential communication. The definition from statute is a communication in which the parties reasonably expected to be confined to themselves. As lawyers, you know that reasonably is one of the main key words in our line of work. And in this penal code and in this scenario, that word comes up again, reasonable. You're going to hear it a lot when you're talking about this. So the legal interpretation of a reasonable confidential communication is in Flanagan, which I cited for you here. If you need the citation, if you don't have the slides, I'll be happy to give them to you. It's a communication is confidential if a party reasonably expects that no one is eavesdropping or overhearing. And then it's a subjective objective test. What does that mean? Let's talk about that. The speaker must have an actual expectation of privacy, and the expectation must be reasonable. So it's subjective, objective. So subjective means I personally, me, have a reasonable expectation of privacy. The objective part comes in, is my expectation of privacy reasonable? Meaning that if anybody else, the majority of the public were in my shoe, would they have that same expectation of privacy? Example of it is I'm sitting in a coffee shop and I'm talking to you. I think that our private conversation is confidential, right? Is it reasonable? Is my thought reasonable? I would argue no, it's not, because we're in a crowded coffee shop. Even though I have a reasonable expectation of privacy, that reasonable expectation wouldn't meet the objective test. It meets the subjective test because I have that reasonable expectation, but my reasonable expectation is not really reasonable when it comes to the objective test. So if the table next to me at the coffee shop is recording my conversation, and I don't know, I'm talking business and my rival gets a hold of that conversation, I can't come back and say it's an invasion of privacy under this penal code because I had a reasonable expectation of privacy, because it's not an objective, reasonable expectation. Excuse me. Some more examples are in-home discussions, private phone calls, personal conversations in a closed office. Those are confidential, okay? I'm having a confidential uh, talk with my client, right? Well, the office walls here are thin. So the office next to me is a lawyer as well, but he could hear my conversations, right? So is my expectation reasonable? Yes, because I'm in a closed office. So he can't go and talk about what I talked about. Um, a loud conversation in a crowded restaurant. It's just like the example I gave you at Starbucks, you're sitting across all. That is not reasonable. Objectively is not reasonable. Subjectively, it could be, but it has to meet both criteria. Subjective, and then it goes objective. Objective is the most important one in that test, and it has to be reasonable objectively. So let's talk about Flanagan versus Flanagan. Uh, in Flanagan versus Flanagan, the son recorded phone conversations with his parents without their knowledge during a family business dispute. Um, and then the parents sued him under this penal code. The Supreme Court clarified that confidentiality turns on the expectation of privacy. The existence of hostility or litigation does not automatically eliminate confidentiality. So in Flanagan, they're having a family business dispute, and it's hostile, and the son recorded him. The court said even though it's a hostile and the hostility exists there, that doesn't mean the expectation of privacy is out the window. And then you can use this argument both in civil and criminal cases. So and then let's go back to this case is called Frio versus Superior Court. Now, Flanagan is from 2002, but Flanagan used Frio versus Superior Court, which is a 1988 case. And out of that ruling came what we call the Frio test. FRIO is the name of the case. So the facts of that case are Frio is a record producer. He was secretly recording telephone conversations with business associates via his answering machine back in the day. Um, he would later review those notes and create deposition notes that he planned to testify to. So he would record conversations using his answering machine, listen to those conversations, and then write down notes from those conversations because he was going to plan to testify on them at depositions. The trial court barred his testimony under Penal Code 632, Section D, which exclude evidence obtained as a result of recording a confidential communication in violation of 632. It went to the appellate court, which was reserved. They said that Frio's independent testimony recounting his firsthand conversation, even if refreshed by notes from recordings, was not evidence obtained as a result of unlawful eavesdropping and therefore admissible. So what did the appeal court say? The appeal court said, look, Frio is testifying from his own memory, right? He had the conversation. Me and him were talking. He recorded me on the answering machine. Then he went back and listened to our conversation, took notes, and testified. He's testifying from his memory. He might be using those notes to refresh his uh, his memory and testify to it, but he wasn't actually introducing those recordings into evidence. So his testimony is allowed. So the appellate court reversed the the excuse me, the lower court. So what does that mean? Well, that just created a little niche. So you have to actually show that the evidence being used was unlawfully recorded. Now, the unlawful recording that Frio had wasn't actually being introduced in this case. He was using it to refresh his memory, so it was allowed. So the takeaways from that case is only actual recordings or derivative evidence obtained directly from the recording device are excluded, uh, not firsthand testimony from participants in the conversation. It's exactly what I was telling you. He was using the recordings to refresh his memory, so his testimony was allowed. And then there is participant immunity doctrine, which arrived from Frio versus Superior Court. And I have the citation if you need it. I don't know if I have it in my slides. I noticed this morning it was missing. And it's 203 Cal App 3D 1480. If you need that, I'll be happy to email it to you. Just let me know. So a person who was a party to the conversation retains the right to testify about it, regardless of whether he made a recording, provided the testimony is based on memory rather than the recording itself, right? So let me give you an example. If you ever handle traffic tickets actually go into criminal court. You have every single right as any criminal case except a right to a jury trial. You don't have a right to a jury trial. You don't have some other certain rights, but you have all other rights. So the officer is supposed to come when you have a bench trial, and if he doesn't come, the case gets dismissed. Why is that? Because the officer is sort of the witness, right? He has to testify. Now, one of the things that we do, when I say we, I mean criminal defense attorneys or people who fight traffic tickets, when the officer starts reading from his notes, we object, right? Because he is actually supposed to have independent recollection. He's supposed to remember what happened without reading from his notes or reading from his report. Now, he can use his report to refresh his memory. And it's like that in other criminal cases too. And I'm sure it's like that in civil. You know, someone testifies and they say something that's different. You say, well, remember on this day you took a deposition, or remember you wrote this report. Uh, isn't that, what did you say? And they go, well, I don't remember. Like, if you look at your deposition or if you look at your report, would that fresh in your memory? And you approach, give it to them, they read it. So they're not actually introducing their report at that point into evidence. They're using their report to refresh your memory. And it's the same thing here. The recording can be used to refresh your memory, and that's acceptable. You can't bring the recording in as evidence. The defense that you could use in this, even when the recording exists, you can argue that your client, being part of the conversation, can lawfully testify based on their own personal recollection, right? So that's um, that's the argument that you would bring in, right? If 632 is being used against you, I'm sorry, let me clear that up. If it's being used against you, that's the argument you would use. And then the Frio test that we were talking about is a two-part analysis. The court established a two-prong test. Uh, and the first one is, was the evidence obtained as a result of an illegal recording? Okay. Uh, it focuses on whether the evidence directly stems from an unlawful act or recording of a confidential communication without consent. So if the first prong is, no, the evidence wasn't obtained from an illegal recording, well, you don't have a problem there. It's done. It's a legal recording. It could be brought in. But if it was obtained from a legal recording, then you go to prong two, and that's if the evidence can be shown to have an independent source such as the participant's memory, it is not considered fruit of the illegal recording or fruit of the poisonous tree, there that it may be admissible. So it's what we were talking about. So that's the two-pronged test. Was it obtained illegally? And if it was obtained illegally, is it something that the person can testify to by memory without having to use or bring in the recording, right? So that's where the Frio test comes in. Um, Also in Frio, the court held that although the defendant had illegally recorded a conversation, his own recollection of those conversations were not obtained, and obtained is in quotes, as a result of the recording, right? So he didn't he didn't learn about the recording and testify. He was part of the recording. Let me rephrase that. Okay, so let's use the same example. Rio is having these conversations. He records them on the answering machine. Then Jack gets a hold of those recordings. Jack listens to those recordings, and then Jack takes the stand to testify. Jack's testimony is not going to be allowed because his own recollection, Jack's recollection, was not was obtained as a result of the recordings, right? He wasn't part of the conversation. He wasn't originally there to talk about, yeah, I talked to Joe. Joe told me this. He wasn't there. He listened to the conversation, and his memory of the conversation is from the illegal recording themselves. Whereas in Frio was part of the conversation. His testimony or his memory is from part of the conversation. He used the recording conversations to refresh his memory. Excuse me. So again, because his ability, when we say his ability, we're talking about the person testifying, because his ability to testify came from his direct participation, not the recording, that the testimony was not barred. Okay, so that's where we go. So this is a crucial test for defense attorneys, at least in criminal cases. It protects clients from blanket suppression when they were a participant in the conversation and can testify from personal memory. And that's if it comes to your benefit, right? You have this evidence, you want to introduce it, your client wants to testify about it, it's going to help you in your case. The other side is arguing that no, it's a confidential recording. It was recorded without the consent of the other party. California is a two-party consent jurisdiction, so it can't be brought in. If, as the attorney, you can argue that your client's testimony, a memory of the conversation is obtained not directly from those recordings are used to refresh his memory, then you can get that evidence in. It also limits exclusion to only the unlawfully obtained recordings and any evidence directly derived from them. Okay. Um, it's a very, very, very uh, fine test when you get to it. So let me go to the next slide. Um, yeah, Flanagan against Flanagan, we were just talking about it. So, and then criminal and civil exposure. Let's talk about this. So PC 632 is a wobbler, a misdemeanor or a felony. In criminal law, we have what we call a wobbler. So, a wobbler could be a felony, could be a misdemeanor, misdemeanor could be a felony, or a misdemeanor could be an infraction could be a misdemeanor. So there are certain crimes that could be wobblers. Battery could be wobbler. This could be a wobbler. So you could be charged as a misdemeanor or a felony. The civil damages under 637.2 is $5,000 per violation or triple actual damages. What does that mean? That means if you're going to win this case in a civil court, you have to prove damages. Okay. You can't just say that so and so recorded my conversation without my consent and invaded my privacy. You might be right. He might have done that and he invaded your privacy, but were you damaged by it? You need to show damages. Most of you who practice civil law can understand. And then if you prevail in that and you win, you can ask for attorney's fees and costs. There's key exceptions. There's no exception of privacy in public. Again, Starbucks, loud restaurant, uh, and law enforcement exception under PC 633, domestic violence threats, and then People versus Givens. I'll get to that case. Let's talk about domestic violence threats. I had a case in 2019. The case went to a jury trial. It ended in a jury trial. So the case is over. It actually went through appellate court. It's over. That's why I can talk about it. So I had a client who was a war veteran. He had PTSD. He was married, and uh, his wife was always accusing him of cheating on her. Now, she had grounds. I'm not saying she didn't, but she would just, and he had PTSD, so she would just, poke at him, not physically, but mentally poke at him. So during this instant, he's lying down in the bedroom, minding his own business. She comes in, she starts, talking to him or asking him, about this, who is this texting you, that, this, and he gets upset. He gets up, they're in an argument. He punches the wall, puts a hole in the wall. She's standing in his way. He's trying to get out. Um, she won't move. He picks her up, puts her to the side. Um, she actually falls to the ground on her butt. He gets out. He starts packing his clothes. She follows him. She's still going at him. Um, he's packing his clothes. He goes to the bathroom to get his stuff. She's going at him. He takes all these perfume bottles and he throws them and he breaks them. He goes back. Um, he's a war veteran. He has a firearm. It's not loaded. He takes his firearm to pack it, to take it with him. And he's holding it to his side. He never points it at her. And he says something like, um, I wish I could shoot you or something like that. I don't remember the exact things. And then he finally leaves, right? During this whole time, she has her phone in her pocket and had started recording what's happening before she stepped into the room. So this whole conversation is on audio. Um, so then after he leaves, she goes, meets up with her sister. They go out, uh they go out, and then the next day they get up, they go to like brunch or something. And during brunch, she's telling the sister about this, what happened last night and going over everything with the sister they talked about last night. Sister goes, you should go to the police. She goes to the police like 24 hours later, reports it. Anyway, my client gets arrested. He gets charged. He gets charged. They had him for felony domestic violence, assault with a firearm. They had him for all these charges. And they introduce this evidence, or they bring this recording and they say, look, we have this recording. Obviously, they turn it over to us because we have a right to see it. So this recording is bad. If you listen to the recording, you can't actually see anything. You can only hear it, but you can hear him punching the wall. You hear her, excuse me, you hear him breaking the perfume bottles. So we're like, what are we gonna do? We can't, this recording can't come into trial. So before trial, we file a motion to eliminate. We bring in the arguments under Flanagan. We bring in the arguments under Frio. We say, look, my client had an expectation of privacy. He's in his own home. He's having a conversation with his wife. Um, he's not expecting to be recorded. She never told him that. He never saw the phone, so it shouldn't be brought in. Well, that's where the domestic violence and threats come in. The court ruled that, it could be brought in because there's an exception. If you believe that a felony is impending, that a felony is going to occur, you have a right to record. So that's what the court was saying. We argued that, hey, she doesn't have, how is she supposed to know? She doesn't have a sixth sense. How does she know if a felony is going to occur, right? The judge wouldn't buy it. The judge ruled against it. So that audio came in. We went to a jury trial. They played that audio. My client got convicted. The gun charge was dismissed. It was acquitted. The jury found that no, he wasn't actually going to shoot her. He just said it. But he was convicted of the other charges because the audio came in. So that's where the domestic violence threat comes in, right? Even if you have expectation of privacy, even if that expectation is reasonable, even if that recording was obtained illegally, it can still be brought in under domestic violence threats if you feel, when I say you, I mean the person who's recording illegally feels that a felony is about to occur. It's imminent. So that's where it comes in. That's where it comes in. So People versus Gibbons. Let's talk about People versus Gibbons. All right. So a police officer recorded a phone call without a warrant during a child abuse investigation. Okay, domestic violence. And for those of you who practice family law, domestic violence, the domestic relationship could be anything. You could go on a date with someone once, that's it. You never see them again, and that's a domestic relationship. So later on, if something happens, it's going to be domestic violence. It could be your brother, it could be your father, it could be anybody you're related to by blood or had any romantic relationship with. So let's go back. People versus Gibbons. This is a 1989 case. The police officer recorded a phone call without a warrant during a child abuse investigation. The issue was whether it's 632 applies here. And the court held that PC 632 applies to all persons, including law enforcement, unless an exception is codified. Without consent or judicial order, officers may still violate 632. And the significance of the case was it reinforces that prosecutors must ensure recording used and evidence are lawfully obtained, and defense attorneys can move to exclude such recordings under Gibbons. So, what does that say? Gibbons is important because it said, look, this Penal Code 632 is so sacred when it comes to privacy that it applies to law enforcement. So officer can't say, "Oh, I recorded this part of my investigation," right? He did. In this case, it was done as part of a child abuse investigation, even though it's a horrible thing. He didn't have a right to record it because 632 applies to law enforcement. So that's why Gibbons is very important. There is exceptions. The exceptions have to be codified, and domestic violence, as we go back to the slide, is codified under 633.5. See, so that exception applies here. Uh, so Gibbons is very important because it's important in criminal defense mainly. It's important in other areas as well, but criminal defense, it goes back to, you know, the government can't just do whatever they want and then use that evidence that they illegally obtain against you and say, oh, we were doing it in part of an investigation. 632 applies to them too. So if there is evidence that's going to be brought in, let's use the example of the case that I had. In my case, the wife was recording my client illegally, but let's say the police officers were there, right? Police came before anything happened, and the police are there and they're recording my client without knowing, and they want to use that recording later, then you can bring in 632. That's a broad example, a general example. As you know now, most law enforcement agencies have body cams. I think the only ones that don't have them yet are CHP, which is surprising because they're the most well-funded law enforcement agency. But they all have body cams, and they are required to turn them on when they're talking to you. It's not on all the time. Uh, Sometimes we get the body cam videos and it's off, or even if it's on, you see like the officer's like eating his lunch or something, and then he responds. Uh, the audio is still not on, the video may be, but as soon as he has interaction, the audio goes on, and you have a right to all those body cam videos. So those actually are allowed, and they're, you know, if they want to use them against you, they're allowed, and you can't. Well, you could try to bring a 632 violation, but it's not going to stick. Okay, so because everybody knows that they have those body cams, and most of them tell them, hey, you're being recorded. So let's see. Evidentiary consequences. Illegally recorded conversations are inadmissible. They may be admissible in federal court. That's a whole different topic we can talk about. Potential suppression and CIPA claims can be brought in, and that's under this code section, Penal Code Section 362D. Let's see what my next slide is. My notes and my slides are a little different, so that's why I'm jumping around, but I want to make sure we talk about everything. So ethical considerations for attorneys. because this talk is designed for attorneys, right? So we need to know this because it will come into practice, and it comes into practice not just for criminal, it comes into practice for family, civil, it comes into all areas because privacy is important, actually, and that is why this, like I said, it was codified in 1967. They thought back then that technology was gonna invade people's privacy, and we're in 2025. So imagine how much technology has advanced. So go back to 67, imagine what the technology was back then. And they were so concerned about privacy and the technology back then that they codified this penal code. So do not advise your clients to record unlawfully. Do not do it, okay? Do not, because not only the ethical part, you could get in trouble with the bar, but it's not going to help you because if it's unlawful, it's not going to come in. Okay. Um, the risk on DV in employment and housing cases. Okay. The DV parts is a little bit harder because you have that exception. But the arguments you could make is, well, the client recorded it because she thought or he thought that there was an impending felony about to happen, but you would have to prove that, right? In my case, uh, I think the police were called two previous occasions. My clients were having a loud argument, so the judge used that to say, yeah, the victim, the wife, had a reasonable expectation that a felony was going to occur, so the recording could come in. Um, and then encourage lawful alternatives, protective orders, witnesses. For those of you who practice family law, or those of you who've dealt with domestic violence restraining orders, or even civil harassment orders, uh, if an order is granted, even if it's a temporary one until the hearing, sometimes they say in the temporary ones, and for sure in the permanent ones, you may record this person. That's why the alternative is to get a protective order. Once your client gets that protective order, they have a right to record that person. They don't need to tell them. Next time the person they have the restraining order against calls them, they could just press record. That person comes to the door, they could just start recording him. They don't even have to use their phone. They could have the cameras recording them. So that's the alternative to getting the thing. So let's talk about some hypotheticals. Um, but before I do that, let's go back to some practice tips. Always get compliance tips. Always get written consent for recording. Okay. Use consent notifications for recorded Zoom or phone calls. Advise clients against recording private conversations without prior discussion. The first part is basically for you, the attorney. The example I gave, you know how we have AI notes, AI taking notes during our conversations. We tell our clients, AI announces it, uh, and our clients sometimes say no, sometimes they say okay. So we record the AI takes notes. It doesn't record the conversation, it takes notes, right? But I'm sure there's some AIs that record the whole conversation, and you can, put them in the file. Remember, even if your client gives you consent to record the conversation or take notes from it, that conversation and notes is still privileged information because of the attorney-client relationship you have. So remember that. Don't think that, oh, okay, they gave me permission to record and it can be used or someone else can use it. So you have two layers of protection. Um, and then your client has two layers of protection. You could actually get in trouble if you use it not for your attorney-client privilege, but for something else. Your client could turn around and sue you under this penal code. Um, and the other one, in criminal cases, for those of you who practice criminal, pretrial motions to suppress, like the one I talked about. Motions to eliminate, you could bring it, at a trial, one of your 402s, or you could file a separate motion on it. In my case, I filed a completely separate motion before I even went to trial and had my 402s heard because I wanted that issue resolved before going into trial because it would change my strategy, the DA strategy. So I would say if you're going to bring a motion like this in a criminal case, do it before your trial. Don't bring it as part of your 402s right before trial. Have a completely separate suppression motion heard before you go into trial and you have your 402s heard. Um, Leverage 637.2, which claims to increase settlement value. Okay, that's the civil part. Leverage that part. When you're doing civil, use that part. And then the ethical considerations, we talked about them, but again, avoid secretly recording opposing parties or witnesses, and know your duties under state bar ethics opinions. Um, I'm not here on a state bar ethics talk, so I'm not going to talk about that. But just remember, uh, you need, as an attorney, not only you have to comply by Penal Code 632, the prong test and all that, you have to comply with the ethics that's set for us by the state bar. Um, Now, let's talk about some hypotheticals. But before I do that, I want to talk about anticipated legal trends. Okay. So, use of smart devices, Alexa, Siri, and their recordings. Um, As you know, Siri, Alexa, all those people, all those companies say you're not being recorded. And then something came out that actually they are recording you. So can they use those recording against you? And answer is no, obviously not. Can they use the data they obtained from the recording, which they've been doing? Compiling data of your likes, your dislikes. That's why people are, sometimes people are like, I was just talking to Joe about blue shoes, and I turned my phone on and there's an ad for blue shoes. How weird is that? My phone is listening to me. Your phone might be listening to you. The argument those companies are going to make is, but if you bought an Alexa, you should have anticipated that you're going to be recorded. It's a weak argument, but they're going to make those arguments. So as technology advances, as technology expands, and new things come into play, this rule is gonna go is going to expand itself too. Um, let's see. Secret recordings in domestic violence. We talked about those in custody and employment matters. Those are going to be areas that are going to be gray areas, in my opinion. And those are going to be, I think, case by case. So if you have a domestic violence case, um, bring up these motions. And the reason I pause is I was thinking, I think it was a couple of weeks ago, actually, I got a call from someone who was in a family law case. And they said, my wife recorded me without me knowing, talking bad about, I think, the kids, talking bad. He wasn't saying something good. He didn't know he's being recorded. Now they're going through a divorce, and the wife is using these recordings and wants to use these recordings in trial. And from what I recall, he said the judge is letting is gonna let the recordings come in. Okay. Um, and I told him, well, you need to talk to your lawyer who's representing you in family law, and have your lawyer handle it. So even in the family law case, I think the motion should be brought to exclude those recordings. In any kind of case, you should bring those motions to exclude the recordings. Um, now, whether they're going to pass new bills or expand on this, I'm not sure. I haven't heard any coming down the pipeline. But let's talk about some hypothetical. So, coworker threatens you in the hallway. Is it legal to record them? Right? What do you think? I say yes, it is, because does it meet the reasonable expectation of privacy? Meaning the person who's threatening you, uh, are they reasonably expecting that it's a private conversation between you and him in the hallway? They could be, because it's subjective. But objectively, is it reasonable? And I say no, it's not. Um, Threatening someone in the hallway, I don't think it's reasonable, because, and even if it is, I think the the exception comes in that an impending felony is going to occur. DV victim records threats after prior report. That's exactly what my case was. And in that case, the judge said, yes, the recording can come in because she thought that a felony was going to occur. And the reason she thought that is because there was prior calls to the police for domestic violence. So she thought that it's going to occur. Landlord records tenant via intercom. That's a good one. So let's go back to the test. If you are the tenant and you are talking on the intercom, right? Do you have a reasonable expectation of privacy? You could argue both ways. You can say he's out on the street and he's talking on the intercom. People could pass by. So even though he might have a reasonable expectation of privacy and it's subjective, objectively, it's not reasonable. But let's say it is, right? Uh, does he think that the landlord is going to record him? No. Okay. Does he have a subjective, reasonable expectation of privacy? Yes. Is his reasonable, is his expectation of privacy objectively reasonable? And in this scenario, let's say yes, it is. Can the landlord then use that intercom against him, that intercom recording? I'm going to go back to and argue on what that intercom is. Um, is it one that automatically records people? Is it one that is the recording one that the landlord is holding the phone next to the intercom? Now that clearly is a violation. So you got to look at the facts. You got to look at the scenarios because, like I said, some of these things fall into gray areas. It could be argued both ways. You have to make sure your argument meets the two-pronged test. And if it meets that two-pronged test. Now, let's go back to this landlord records the tenant via intercom. Um, let's say it's illegal, the recording can't happen. But the landlord is now going to testify in the UD action, and he is going to testify himself. He's using the recording to refresh his memory, but he's not bringing the recording in. Can he do that? And the answer is yes. Remember, we talked about it because he was a party to the conversation. He is using the illegal recording to refresh his memory, but he was a party to the conversation and he can testify as to what he recalls from the conversation. The recording can be brought in, but he can testify and use the recording to refresh his memory. And then we talked about that. Let's see. I think that might be my last slide. And oh, yes, key takeaways. Understand the scope of PC 632 and two-party consent. Uh, Remember, California is a two-party consent jurisdiction. Some jurisdictions are one-party consent. If one person agrees to be recorded or records the conversation without the other party recording it, it happens. Off the top of my head, I don't know any jurisdictions like that. But then again, I really don't practice in any other jurisdictions unless it's a federal case. Be aware of criminal and civil exposure. You could be charged criminally and you could be sued civilly for the same set of facts, same scenario. The government could bring criminal charges against you, and then you could be sued civilly. You can have two things going on at the same time. Know the expectations. I'm sorry, the exceptions. Know the expectations as well, the expectations of privacy, and know the exceptions. The exceptions that we talked about. And then protect your clients through clear guidance. Like I said, don't tell them to record stuff illegally. If if they don't have an order allowing them to record a conversation with another party, don't tell them to record that conversation. If they're going to record that conversation, make sure they have consent of the other party. Make sure that if they're worried about being recorded, they should keep their conversations to somewhere where their reasonable expectation of privacy is objective, not subjective. Subjective is the first prong, objective is the second and most important prong. So those are the key takeaways. That's my contact info if you need anything. We do have about 10 minutes. We can go over some more. I know some of you have lots of questions. Let's see. Okay, this one says, how does this apply to custodial parent recording their minor child when in the custodial parent's home? Parents are divorced. So, from my understanding, Um, you're asking, how does this apply if I'm the custodial parent and I'm recording my minor child? So who's going to argue that that was a not confidential? The other parent, right? I would argue, I don't do family law, so, but from off the top of my head, I would argue that other parents doesn't have standing because the minor child is the one being recorded, not the other parent. If it's going to be brought in trial and the other parents wants to object to it, they can object to it for other reasons. Um, Even though they don't have standing, they could argue the minor doesn't have the ability to give consent. So uh, the minor shouldn't have been recorded. But then again, I don't know this, I don't practice family law. Do you have a right to record your own child? So uh, I don't know that answer. So that's a good question. I haven't come across it, so I'm sorry if I don't have a clear-cut answer for you. What about a baby camera video and audio? What would that be considered consent by a party if it's in their house, recording a grandparent? So yes, so I have cameras in my house, right? If I have like a babysitter, the babysitter knows I have cameras. So is it a reasonable expectation of privacy? She's coming into my home. Does she have an expectation of privacy? She does, but how much expectation does she have when she sees those cameras? She knows those cameras are there for a purpose, right? I didn't put cameras there to record myself. So I can argue that her expectation of privacy is not reasonable, even subjectively. But let's say subjectively it is, because, right, it's subjective. So she believes that, hey, I'm a babysitter, there's cameras here. I don't think you still have a right to record me. Uh, is it objectively reasonable? And I would argue no, because most of us put cameras in our house to record uh, third parties, housekeepers, babysitters, gardeners, things like that. So I would say that that recording would be allowed. Okay, let's talk about, may a consumer record if a biz records? That's a great question. Um, I would say you would have to tell them, just like they tell you. They tell you this conversation may be recorded. You tell them the same thing. Tell them, hey, I'm going to record you and see what they say. Um, and then press the record button. If they say yes, if they say no, then it goes to the courts, right? But again, just like they give you warning that they're going to record you, I believe you have to give them warning too. So just because they gave you warning doesn't mean you have a right to record it, right? They're telling you they're going to record you. You can object to it. You have to do the same. You have to tell them, I'm going to record you, and they have to object to it. Even though they are a business, it still falls. Remember, even law enforcement is bound by this law, okay? Um, in a criminal case, isn't the recording admissible regardless of 632 violation under the truth in evidence clause of California Constitution? Yeah. Well, excuse me. Let's go back to what we were talking about. Um, Remember the two-prong test in PKO. So the appellate court, I'm sorry, the lower court said it can't be brought in, right? Because it was illegally obtained. The appellate court said, no, it could be brought in because he's testifying to it as his own memory, right? So is it admissible under the truth and evidence clause? I'm going to say no, it's not. Because if that exception falls, if that exception applies, then the rule will fall apart. And then everybody could say, oh, it under this truth and evidence, it could be brought in. I think it's very specific. I think Frios said this, the prong test. Flanagan also expanded on it. Um, and it has to go through those process before it could be brought in. You can't just say, well, under truth and evidence clause, it could be brought in. That's an argument you can make, but I don't think it's going to win every time. It might win, but not every time because you still have to go through the process. Um, Penal Code 632 and everything that applies to it is very specific. And remember, California privacy laws are, or California prides itself in privacy laws, right? Believe it or not, they do, and uh, they try to make sure people's privacies are met. So they're not going to allow a broad exception like that to come in and take away those rights. Remember, they were worried about tape recorders when they enacted this statute. So um, that's how sacred they believe privacy is in California. Uh, what about an employee recording a termination meeting when there was a boss, an HR person, and a terminated employee? Well, if they said, come in, sit down, let's have a talk, and you're being recorded, yes. If there's cameras, yes. Like I have cameras in my office. I have a camera right now. It's not recording, but it's set on, after hours, it can record if there's a motion. So if I walk in, I'm the employee, and I walk in and I know my boss has a camera in that room, that expectation goes away. So if there is HR in that room, I'm sure HR knows the policy and HR would tell them. If you're secretly recording, then you might have a problem. They have to have, remember, it's a two-party consent state. So they both need to be, and their expectation is could always be subjective because it's subjective, but is it objectively reasonable? If I walk into a private office and I don't know I'm being fired and they fire me, um, and they recorded me without me knowing, is my expectation of privacy not just subjective but objective? I would say yes. So I'm going to argue it can be brought in unless that person being recorded had prior knowledge they're being recorded. Let's see. What is the reference to employment and housing about? Uh, just what we talked about, like employment right now. If you're going to fire someone and you're worried they're going to do something and you record them. So if you're worried that they're going to commit a felony, you could record them without their consent. But how are you going to prove that they're going to commit a felony? Well, maybe because they committed a felony before, or they committed a crime, or something like that. And housing is the same thing. You're recording your tenant because you say that they're doing something and you want to kick them out. That's why it comes up in employment and housing. And the cameras in apartment complexes, things like that. Um, let's see. What if someone is recording the other without their consent, and the other person tries to snatch the cell phone since they don't want to be recorded? Is 632 still applicable? So that scenario will create different things. So if they're recording you and you don't want to be recorded, you got to go back to the test. Is there a reasonable expectation of privacy, uh, subjectively reasonable? You could say yes because it's subjective. Is it objectively reasonable? Meaning, if you're recording someone in public, right there in the street, and you start recording them, then I would argue their expectation of privacy is unreasonable. And if they tried to snatch the phone, now they could be charged with a battery, right? They could be charged with, theft or whatever it is. So go back to the prong, go back to the test. When you're not certain about the scenario, go back to the test. Uh, Subjective and objective. Is there expectation of reasonable? Is there expectation of privacy subjectively reasonable? That's going to be a yes automatically because it's subjective. Uh, you might have some things where it's so what, even subjectively it's not reasonable, but objectively is it reasonable? That is the key right there. So if you're recording someone without their consent and they don't want to be recorded and they try to snatch your cell phone, go back. Was their expectation of privacy reasonable objectively or not? Okay. um, Family law case. My client has videos of physical abuse from ex-husband to child and to her. Father admits to biting and beating his children. It sounds like 3 6. Well, in that scenario, is the husband trying to fight those recordings come in? Um, and if they are, then you could fight, with the domestic violence exception. You could try to bring it in. So I don't know enough about those facts to know, to give you a clear answer. But again, remember, uh, if if the husband is not arguing about those recordings being coming into trial, you're good to go. And if they're arguing about it, then go through the two-prong test, right? Um, the person is their home, even if they're committing child abuse. Uh, Unfortunately, it's a sad thing. But even if they're doing that, is their expectation of privacy reasonable subjectively or objectively? And if it meets those, then you need an exception. So the domestic violence, I would say the domestic violence exception would fall into play here. And I would argue that if the other side is trying to prevent those recordings from coming. How realistic is a criminal prosecution for these claims? So it's realistic, but usually you don't see a criminal prosecution of just discharge. Discharge will go along with other other charges. Okay, uh, I rarely seen just one count charge on these. They go hand in hand with other charges, and they are realistic. I mean, that's why it's there. That's why they have the penal code. That's why they take it so seriously. They do prosecute people for this. Um, they're not going to prosecute you for recording your girlfriend um, without her consent and then sending the recording to her mom and she gets in a fight with her mom. They're not going to prosecute you for that, even though it's illegal and you committed a crime. They're not going to do it for that. But they are going to prosecute you, and these charges go hand in hand with other charges. If my answering service provides a notice that we record for quality, and then I am going over, so this will be the last one. I believe the other ones we can answer through email. If my answering service provides notice that re-record for quality after call is transferred to me, may I automatically record without another notice? Yes, you can. That's basically every call center, right? You call, they go, this call may be recorded, and then you get transferred to A transfers you to B. So the answer is yes. Okay, I'm told that I can't go over, or if I go over only a few minutes, there's some more questions. I think there's a bunch of outstanding questions. I'll be happy to answer those through email. Thank you, everyone, and have a good night.